Good day, Mr. Allen. I appreciate you being here with me today. In this video, I will go over some important details about your recent purchases of the Pineview Cottage, especially regarding the Land Registration Act 2002 and any potential claims or rights that other people may have over your land. We will go over how the legislation shapes ownerships, what is meant by overriding interest, and how Tina's and David's claims may impact your right as a new owner. The Land Registration Act of 2002 ensures that the official property register serves as the main resources for verifying a property ownership. According to Section 58 of Land Registration Act 2002, a person is the legal proprietor when they are registered as the owner. As a Pineview Cottage new owner, you are well protected by these acts. According to the journal article The Land Registration Act 2002, The Shore on the Road by Simon Gaynor, it states that Land Registration Act 2002 replaced the Land Registration Act 1925. It aims to improve the property right stability and transparency and lessen the legal uncertainty for both buyers and landowners. This implies that anyone purchasing a property, such as you did when you bought the Pineview Cottage, you can look out the property's ownership and any interest or claims by other people using this land registry. Although the majority of the necessary information is captured by this registration, certain rights may have an impact on the property even if they are not recorded. I will go into greater details regarding overriding interests, which are unregistered but nonetheless legitimate rights. According to the journal article The Land Registration Act 2002 by Geoffrey Salmon, Land Registration Act 2002 also introduced a framework of e-conveyancing, where the e-register will govern the vast majorities of dealings with lands. This simplifies the property transaction by reducing the need for paper deeds. Land Registration Act 2002 speaks out and improves the efficiency of property transaction. This registration streamlines the purchasing and selling procedure by reflecting all the interests impacting the land. Before I start with the main question, I will explain some principles related to the Land Registration Act 2002. Three fundamental principles which underpins the Land Registration Act 2002, which was created to safeguard the property owners and foster confidence in the land registration process. The first principle, which is mirror principle. This concept makes sure that all important details about the property, such as its ownership, any restrictions or burdens, and any registered interests are reflected in the land registry. Ideally, the register should contain all the information that a buyer needs to know. For the curtain principle, this principle eliminates the needs for additional research by enabling the buyers to rely on the information found in the land registry. The purchasing procedure will be easier and less stressful if a buyer may fairly presume that the property is free of other significant claims if they notice no registered claims or restrictions. Last but not least, the insurance principle safeguards you in the event if the land registry made mistakes. You can be entitled to compensation if there is a mistake or omission in the registry that impact you as the owner. Third, this idea combined to provide you with an exact and clear view of your property. However, there are still some certain exceptions to this, which are known as overriding interests, which may override your ownership title. According to Section 29, Subsection 2A, Roman 2 Land Registration Act 2002, it states that the purchasers are bound by certain overriding interests even if they are not registered in the land registry. Interest that overrides these interests, although not entered on the register, will nevertheless bind the third-party purchasers, in other words, crack in the mirror. Because the mirror principle in registration system shows that register is an accurate and conclusive reflective of ownership title and relevant interests affecting the land in question. There is a reason for overriding interests. They acknowledge that the owner of certain rights may be very dependent on them and that they could be negatively impacted if they were simply ignored when the property changed hands. Third, they permit some unregistered rights to remain in effect. Schedule 3 of Land Registration Act 2002 lists out all categories of overriding interests. For short leases which are listed under the Schedule 2, Paragraph 1 of Land Registration Act 2002, if there is a lease in a property which is less than 7 years, it may override the alien's title even though it is not registered. Leases with a duration of 7 years or less are exempt from land registry registrations requirements. This implies that even if the property isn't registered, a person with a short lease may still be able to occupy it. For the rights of occupiers, for example Tina, who is living in the second floor at the Pineview Cottage, under Schedule 3, Paragraph 2 of Land Registration Act 2002, rights of people who are in actual occupations of the property may override alien's title, even if they are not registered. A new owner may be still bound by an existing occupant's right to occupy the property if they have been residing there openly. For squatters' right, through an adverse occupancy, a person who has occupied a piece of property for an extended length of time without authorizations may acquire squatters' rights. This implies that a squatter may acquire legal rights over land they have occupied for a long time under specific circumstances. Lastly, an easement is the right to utilize a portion of land for a certain purpose, such as the right of way, and a profits enables someone to take resources from another person's lands. Even these rights are not listed in the land registry. They may occasionally supersede your title. For instance, an easement that supersedes your title may exist if someone has the rights to cross your property in order to go to their own property. Therefore, even if the Land Registration Act 2002 offers you a high degree of protections, alien ownership may be impacted by this overriding interest. According to the journal article, A Critical Analysis on the Abolition of Overriding Interests in Land Law, Giving Way to the Mirror Principle by Ryan Omer, it states that overriding interest has established an unbeatable reputation for having a contentious influence on contemporary land law. It has evolved into a problem that has raised concern about their very existence and sparked intense discussions about potential change. The mirror principle is directly violated by the power to bind the buyers and third parties. After briefing with these few principles, now let us start with the Tina's claims. According to Tina, she and Charles have a 5-year contract that allows her to remain in a room on the second floor of Pineview Cottage, and she had already lived in for 2 years and now still allowed her to remain for another 5 years, which fall under the categories of overriding interest called short leases. But somehow, Ireland cannot find the record in registry lands. In these circumstances, as the Tina has a short lease, it does not always need to be recorded in the land registry. In particular, it specifies that leases with a duration of 7 years or less constitute an overriding interest, meaning that they can bind future buyers without having to be registered. Even if the lease isn't listed in the land registry, the tenant's rights to occupy the space can supersede the registered titles of the new owner. So, Tina lease may bind aliens. Thus, if it meets the Land Registration Act 2002's requirements for an overriding interest. Ellen would have to let her state. However, she needs to fulfill the specific legal requirements which we will discuss next. In order for her lease to be protected, she must fulfill few requirements. In the case of the Strand Securities and Caswell 1965, to establish an overriding interest, one individual may occupy land on behalf of another, and it is necessary to have an interest in the land and be in actual occupations. It is acknowledged that the burden of overriding interest lies in the case such as Hodgson and Marks, where the purchasers are considered disadvantageous. However, they are not unfairly disadvantaged as they are in the fair protections of those in actual possessions. Tina must be in actual occupation in order for her lease to be considered an overriding interest. Tina is physically present on the property in a way that would be apparent to someone inspecting it, which is known as actual occupations. According to the journal article Overriding Interest, Registration Gaps and Actual Occupations by PGMC Hutch. It states that if someone is obviously using or drilling in the property in a way that a prospective buyer like Alan would notice, they are deemed to be in real occupations. According to the court rulings, being employed does not need a person to be present all the time. Tina wouldn't lose her genuine occupation status if she took a short vacation, but she wouldn't be seen as in occupation if she left with no intentions of coming back. In the case of Williams and Greenspan and Boland, it states that actual occupation is the question of facts, not questions of law. Actual occupation arose when someone has a physical presence on the land. Since Tina has been residing in the Pineville cottage for the past 2 years, it appears that she satisfies the actual occupation criteria. Her right to remain in her room may be legally enforceable against Alan. Now, let us discuss about David's claims. According to David, he and Charles signed a contract 3 years ago that offered him the option to purchase the Pineville cottage. This indicates that he thinks he has the authority to purchase the property from Charles if he wished to do so. However, Charles was unable to locate any documentations of this option in the land registry. The option to purchase does not fall under overriding interest categories. In the journal article, The Law of Equitable Rights and Interest in Real Property Law by Clement Chickball, he emphasized equitable rights such as option to purchase are generally need to be registered in order to be effective against the subsequent buyers. Although the purchase option is regarded as an equitable interest, it cannot impact Alan's status as a new owner in absence of registration or an overriding interest claim. The Land Registration Act 2002 guarantees that unregistered interests such as David's option to buy cannot be enforced against a legitimate buyer who pays the full value of the property and is unaware of the unregistered interest. According to Section 27, Subsection 2D Land Registration Act 2002, it states that no registration means no binding effects, and Section 29 Land Registration Act 2002 states purchasers only bound by rights enter on register and interest that overrides. Although an option to buy is a legitimate property right, it usually needed to be registered in accordance with the Land Registration Act 2002 in order to bind a new owner. It appears that David's option was not registered since Alan was unable to locate it in a registry. In the case of Ferry House Limited Company and Wellside Limited Company, it includes an important question about whether a land purchase option might be enforced in case where the interest was not registered. In the case of Midland Bank Trust Co. Limited Company and Green, the court ruling further strengthens the law that a later buyer cannot be bound by an unregistered option to purchase unless they are probably registered. In this instance, the court decided that unless an equitable interest had been registered in the land registrations, an unregistered interest, for example, an option to purchase, does not automatically bind the new owner. In the case of Scott and Southern Pacific Mortgage Limited Company, the option to remain in the property as a tenant was not registered as an interest in the property, therefore did not bind the mortgagee. In the journal articles, option to purchase as an interest in land by Willis B. Jones, it states in the Land Registration Act 2002, the option to purchase bind future owners if they are successfully registered. Unless those interests are classified as overriding interests, the law generally shelves purchasers like Alan against unregistered interests. Since David does not really occupy or actively use the land, his option does not constitute an overriding interest in this instance. His option is therefore unlikely to have an impact on Alan's ownerships. In conclusion, overriding interests are often considered to be cracked in the mirror, which introduce criticism on a number of bases. The existence of overriding interest means that absolute title cannot be absolute in true sense, because the register may not be a true mirror of the stake of the title. To summarize Alan's positions, if Tina Lee satisfies the Land Registration Act 2002 standards for actual occupation and other circumstances, it can be considered an overriding interest. Since she has been living there for 2 years, her lease will bind Alan as a new owner. Therefore, Alan will have to let her stay until the end of her lease. For David, since his option was not registered and does not satisfy the requirements for an overriding interest, it probably has no bearing on Alan's ownerships. Alan should not be required to respect his choice because the law shields him from such unregistered interests. This point indicates that David's option shouldn't affect Alan's ownership's rights, and Tina Lee's should be the main considerations. Thank you.